The
Speaker.
gentleman from Arlington, Mr. Lopez.
Thank you, Mr. Speaker. Speaking to the bill.
The gentleman has the floor.
Thank you, Speaker. This legislation would mandate localities to strictly enforce federal immigration law to the fullest extent permitted by federal law. While this may sound simple, this bill ignores the complicated nature of federal immigration law and could require localities to choose between complying with an ICE detainer or unlawfully detaining someone past their release date in violation of the U.S. Constitution. Additionally, this language is problematic because localities are permitted to assist ICE agents through a program called 287G, but are not required to enter into these cooperative agreements. It's permitted versus required. That's the insidious language. HB 2000 seems to imply that if a locality does not enter into this permitted 287G agreement with ICE, such locality is violating state law. This would make it very difficult for Virginia's cities and counties to adopt common sense policies that build trust between police departments, public schools, and immigrant communities. In effect, this legislation makes our communities less safe by stoking irrational fears of immigrants and undermining the community-police relations that are essential to true public safety. In addition, Virginia already has restrictive immigration laws. While none of these laws address the real problem, our broken federal immigration system, the result is there are and can be really no sanctuary cities in Virginia. Currently, Virginia's local and regional jails are required to turn people over to ICE prior to their scheduled release date if there is a valid detainer request. Virginia also requires status checks for everyone arrested and presumption against bail if there is a detainer placed on an immigrant accused of violent crimes. Just last year, Virginia passed a law that further facilitates interaction between federal immigration authorities by giving jail and corrections officials the authority to release a person into ICE custody up to 5 days before they have completed their sentence on a state or local offense. Coupled with the federal practice of running all arrestee fingerprints through the immigration database, Virginia law ensures that ICE has notice and plenty of opportunity to initiate removal proceedings immediately and before the person is released from state or federal custody. The combination of the Dillon Rule and existing state mandates make the existence of a sanctuary locality a legal impossibility in the Commonwealth. The burden of federal enforcement agencies should not be placed on local jurisdictions. Forcing localities to act as a substitute for federal agents will place additional and undue demand on resources. ICE usually does not reimburse localities for holding individuals past when they would otherwise be released. This takes away from the time and resources that police officers would otherwise spend on public safety and law enforcement. Ultimately, this bill is unnecessary, costly to localities, and could make us less safe by undermining local law enforcement. I hope it be the will of the body to oppose this bill.